procedures, as much as how you want to follow, the court rules, it is equally important for you to ensure that the judgments delivered are made public. Do you think the Singapore judgments are public? Are the judgments available to the public? In Singapore?
Yeah.
Who said yes?
Kabir.
Who is that again? Sorry.
Kabir.
Kabir.
Yeah, Ahmad.
Okay, sorry. Ahmad, how many names do you have?
3 given names.
Are you serious?
Yeah.
Okay, now getting back to this, why do you say Ahmad? Why do you say that? Is your name Ahmad or Hamid?
Pronounce it as Ahmad.
Okay, but actually it's supposed to pronounce as Ahmed, right?
Yeah.
So, can you tell me why did you say that the Singapore judgments are made public? How do you know they are made public?
I guess also you can find some of the or rather most of the judgments online.
Yeah, correct. These judgments are available for free. We don't need to pay. Correct or not? You go to the Singapore Supreme Court website, you can download the judgments, High Court and Court of Appeal judgments. Likewise, if you go to the if you go to the UK Supreme Court website, you will also be able to download the UK Supreme Court decisions for free. But what if it's a Court of Appeal in the UK? What if it's a High Court? What about previous House of Lords judgments? Remember we went through Westlaw last week? You can download all the judgments for free, right? So that is how these judgments are made public. Made public means the public are familiar with these cases here. Okay? So if let's say now, you read a judgment, you are the claimant, you think that the judge has applied the wrong law. The judges have interpreted the law. This will give you an opportunity to appeal to the appeal court. So this public judgment, this open justice, is actually a very, very good platform for us to appreciate and understand the basis in which the courts arrived at the decision. This would in fact strengthen rule of law because you can prevent the judiciary from making arbitrary decisions. When you can prevent the judiciary from making arbitrary, because you know that the judge in deciding your case must apply precedent or must apply statute laws. You don't want the judge to give his or her own interpretation, right? So write down the basis of your decision, okay? Now, a very old jurist and academician, of course not alive today, Jeremy Bentham. Bentham basically writes about the philosophy behind the law, okay? So in his writing, he basically says that where there is no publicity, it means there is no justice. Which means in all civil justice system, in order for you to achieve justice, there must be an open court here. In fact, he described this as one of the most important aspects of justice. Okay? So with that, we have seen now who is the civil justice system for and what is the important component of the civil justice system. Now, the last part, how does the court process work? Okay? The court process works on the basis where when there's a dispute, you can either negotiate and resolve your dispute. So for example, if you have dispute with your employer, you don't have to straight away take your employer to the court. You can try to negotiate. In fact, negotiate is the lowest form of ADR, right? You can try to negotiate your conflict with your employer. And if you think that doesn't work, you want to take one step ahead, you don't have to jump into litigation, but what you can possibly do is you can either opt for mediation or you can opt for arbitration, one of it. Okay? Now, if it doesn't work, if the ADR doesn't work, DF stands for defendant, okay? Then you can actually go to the court. But the problem here is when you go to the court, the defendant is forced to appear in the court. Whereas that's not the case in private resolution. Is ADR voluntary? Yes or no? Is arbitration and mediation voluntary?
Yes.
Yes, it is voluntary. Jinling, why do you say no? You cannot force a person to arbitrate. You cannot force a person to mediate. But if you decide to sue a person, if let's say I serve you the writ of summon, I'm saying that I want to summon you to the court, you have to come to the court. If you don't go to the court, I can get a decision against you. So that's the essential difference between the workings of the courts and ADR. Okay, ADR is not forced. ADR is usually voluntary. Okay. Which court does it go to? As I mentioned, it goes to the county court first. That's the lowest civil court. And then from there it goes to the high court. Okay? The term litigants and litigations are different. Litigation is the process. If you want to sue a person and if it's civil case, we call that litigation. But the claimant and the defendant are both called or both known as litigants here. So the term litigants and litigations must be used in different contexts. The next for you to appreciate, the next for you to understand is procedures here. So when it comes to procedures here, procedures is where we are looking at the issue of the proceedings. So when it comes to issues of proceedings here, you have to serve these documents. When I say you must issue these documents means you must issue the documents in the context where we have to look at how these documents are compulsory. For example, like I mentioned earlier, you will have to serve the writ. So when I say you have to serve the writ means, that is the writ is one example. The writ is usually followed by statement of claims. So you also have to take note of the statement of claims that you have, right? So these documents are fixed documents, and if you actually don't produce these documents here, you will not be able to proceed with this. So in that context, it can actually be rigid. Okay, so when I say it can actually be rigid means because it is mandatory for you to go through this aspect of the law. Okay. Now the next point here is defendant. So what is defendant? Defendant, DF is defendant. This defendant now has got no choice, like I mentioned, because this defendant now has to, this defendant has to respond to what the claimant has said. Okay, so when I say you have to respond to what the claimant has to say, you got to defend yourself. If you don't defend yourself, you're going to lose the case. So defending yourself as a defendant is so essential. It is so important basically. All right. So take note, you have to defend yourself. And if you don't defend yourself, there's very high chances for you to lose the case. Okay. Then this case will also, once the defense have been received, will be managed by the court here. So this is where we look at case management tracks. So when I say case management tracks means we are looking at the registrar now will see the claimant has said this, the defendant has given me the statement of defense with all his defenses, how he's defending himself here. Then the registrar will give the parties the time to go and collect evidences, prepare your case for trial. Alright? Once you're prepared, you come back to the courts, the registrar will look at your case, and in Singapore we call this PTC, pre-trial conference. The registrar will see, are the parties prepared or not? Are your documents prepared? Who are your witnesses? Do you have your witnesses? How many expert witnesses do you have? All of these will be collected and prepared. Once the registrar is convinced, only then you will go for trial. Okay? So at trial, claimant must present the case first. Once the claimant has presented the case, then the defendant will present the case. So then finally, the courts will deliver the decision here. Okay? So in that context, in that aspect, you got to bear in mind that we will have to make sure, or rather we have to ensure that these processes must be followed. You don't follow these processes, of course you will not be able to, your case was not going to go to the court. Okay, so following these processes are so essential and they are very, very important. All right, okay. Now that we have seen this general process here, please take note that when your trial has commenced, once your trial has commenced, you still have an option to resolve the conflict with the other party. That process is called out-of-court settlement. Out-of-court settlement is different from ADR. ADR is something that you try before litigation. ADR is something that you try before your case goes to the court. Okay? But halfway through during the proceedings. Okay? Halfway through during the proceedings. In this instance, what will happen is, if let's say you want to stop the case, then in this instance, you can stop the case. And when you stop the case, you are going out of the court to settle, right? You can do that. So then you'll have to just withdraw your case. But this out-of-court settlement is an option available right up till the judge gives the decision. Okay? So when we speak of this out-of-court settlement here, you must understand here, it is still normal and it is also a process where we encourage the parties to do this. Because in out-of-court settlement, you will still be able to get a win-win situation. So there's a little negotiation in your out-of-court settlement. Okay? Because the courts are not involved here. But it has to reach before courts give decision. Usually, the settlement will be reached, in fact, before even your trial process commences here. Okay? But trial will only take place if, let's say, you cannot reach. But can you still opt for out-of-court settlement during trial? Can. Okay, that is possible. So this diagram is just to illustrate briefly, to give you an overview of the court's procedure. So let's say now, look at the options that you have here. Dispute arises, you want to resolve through negotiation, it is possible to settle there. You can try informal resolution if not possible. Informal resolution means like mediation, all right? You can talk about other forms of tribunal, or you can get advice from your lawyers. You can try to involve your lawyers to settle. Court proceedings can be summoned. During your exchange of documents also there could be settlement. Then during the case management also there's an option to settle. During collecting evidence also there's an option to settle here. There are so many opportunities for the parties to settle. Okay? In fact, parties are highly encouraged to settle their disputes. And the reason why they're highly encouraged to settle their disputes, it is because you can save the court's time. When you save the court's time, when you're able to resolve the disputes, the courts will use the time to hear a much more important or serious cases. Okay? Now, let's try to reflect on this and end the first part of introduction. Why do you think court proceedings are issued if, let's say, parties can still continue to negotiate and settle without even getting the courts here? Why? That means look back at this diagram. The question is asking you, why do you allow the parties to still settle while preparing for trial? Do you think it should be allowed or not? What do you think? Should it be allowed? Why do you say yes, Amelia?
Because it's better they settle it themselves. Come to an agreement through discussion.
Why should they come to an agreement for discussion? Why is it better?
It's more win-win than
Okay.
less adversarial.
But now, instead of looking at it from an individual, let's look at it from a civil justice system. Why, when parties resolve the dispute on their own, why is it benefiting the system? How would it benefit the system? We always look at it as an advantage to the individuals, right? You save money and then it's a win-win. But now I'm taking you one step further. I'm saying when there's settlement at various stages here, how does this benefit the civil justice system? I did speak to you about it earlier. A bottleneck example. Can save the court's time. Yes, save the court's resources. Very good. Yeah, correct. So for those reasons, that's the answer to this question. So when the question says, why court proceedings are issued if people continue to negotiate, right? It's for these reasons. We still want to encourage them, see if you can settle through various stages of negotiation. You're still able to save the court's time and legal aid. You don't have to tap the state's fund. Because when you go trial, you're going to have expensive legal costs. But if you can resolve all of this before it goes to trial, your legal fees is very little. So the legal aid that you claim from the state is also lesser. Right? So that's when Michael says resources, the resources also includes funding by the state here. Okay? All right. So with this now, I complete my first set of lectures, which is on Introduction to the Civil Justice System. So to give you a quick recap of what we have done, I'm going to take you back to the learning outcomes. We've covered all 6 points. I've spoken to you about the differences between the civil justice and the criminal justice system. We spoke about the scope of the civil justice. Who is it for? We spoke about it's for public. And the accessibility, we spoke about ADR and the trials here. Okay? All right. Do you have any questions that you would like me to address? No questions? Okay, then we move to slide number 2, pre and post Wolf reform. Recess time, with shortly Constantine at 8 o'clock, okay?
Yes, teacher. Thank you so much.
Welcome. Okay, now when we speak of, now you see my slide here, pre and post Wolf reform, okay? So when it comes to this set of slides, if you look at the learning outcomes, here we just want to look at what were the problems before the Wolf reforms, okay? I mean, if I'm going to explain to you about the Wolf reform, technically you must know why this reform took place, right? There must be some problems which has resulted in these reforms. So let's discuss the problems first. Then I will explain the recommendations introduced by Lord Wolf. Okay? We look at the changes. Then in the third set of slides, we're going to talk about some criticisms of Lord Wolfram's proposals, whether they are effective or not. Okay? You understand? Okay? So that's the learning outcomes here, right? Number one, let's address the first part, the problems of the Wolf reform. So I'm taking you back to a time before 1999, okay? If you're asking me why did I just suddenly come up with April 1999? Because April 1999 is where the Wolf reform was implemented. New reforms was introduced in 1999 April. So what was the system before that? Let's talk about the system before that. The system before that is very expensive, the civil justice system. Very expensive is because the legal fees is just too expensive. So when we say the legal fees are too expensive, your lawyers were claiming a lot of money. So when I say the lawyers were claiming a lot of money, so this is where you must appreciate and understand these lawyers basically, it's just a matter of cost, because you pay them for, or when they have legal documents, pre-trial cost, trial cost, all sorts of costs involved here. There's a lot of delay because too many cases going to the courts, and you have only civil county court and then the high court. So when there's delay, of course, it results in injustice. What made it worst is the adversarial process. And the adversarial process allows the parties to bear the burden of proof, right? So if I want to sue Amelia, I have to establish my case, and I can go on and on and on, bring in all sorts of evidence. It's just draining, time consuming. Not only time consuming, it's going to cause delay here. All right. So these were the scenario of the civil justice system before 1999. All right. So let's talk about the cost here. So this legal cost, in some cases, they exceeded the compensation claimed. So usually, especially for small cases, if let's say the damages sought is below 12,000, your legal fees end up 40% more than 12,000. It doesn't make sense, right? So as a litigant yourself, when you know that your legal fees is more than the compensation that you are going to claim, are you going to continue with the case? Are you going to continue with the case, or you will drop the case? You're going to drop the case. Some people, they will end up spending so much, and then they realize that, oh dear, this legal cost is so expensive, halfway through they stop. They pull out because they got no more money to go ahead with. It's a pity, okay? To give you a specific example, defamation cases. Defamation cases, if you go and read reports, not the case judgment, critics on defamation trials, claimants have reported by saying that in papers you look at the compensation 200,000, 1.2 millions. The claimants say those damages are just nice for the legal fees. They actually don't make much money. They just want to reinstate back their reputation. So the figures look like a 5-star figures, but they are not enough for their legal fees. Okay? There's a very, very popular case against, it's a legal aid case. 2 individuals, they were promoting they were trying to create awareness about McDonald's food which is not healthy, which is true. Okay, so in this case here, let me see, I can share any link for you or not. So these 2 guys are basically social workers. It's called the McLibel case. You can just do a Google search on McLibel case. In this case here, it is one of the longest trial in British history, UK history. These McDonald's decided to sue, okay? These McDonald's decided to sue the two social workers for spreading false rumors about McDonald's. Okay? And these two guys didn't have money. They had to fight the case on their own. And you know what lawyers were doing? Lawyers know they can't take up the case because they're going to incur a lot of time and I'm going to lose money. I rather do a case where I can work and earn money. Some lawyers were just giving these two parties free advice. You do this, you do that, you do that, you can argue like this. These are all alarming. You know why is this alarming? Can you imagine you pick up two layperson from the society, you couldn't tell this person here, you're going to defend yourself in the court. What does he know about the court system, you tell me? You're a law student yourself. If I were to ask you now to go and defend yourself in the court system, you will still feel nervous, despite studying halfway through your LLB. Am I right or not? So can you imagine the emotions, the dilemma, how the system works here is really unfair here. Especially when you look at some cases, especially civil cases, they're extremely complex. So when they're extremely complex here, it can also be lengthy. This trial can be very, very lengthy. Okay, so when it can be very, very lengthy, this is a disadvantage. This is not only a disadvantage, but this is injustice. It will result in injustice. So do you see the cost factor is related to injustice? Everybody must, would you agree with me if I were to say everyone must have access to justice? Right? You think, you write this down in your notes, because the point that I'm trying to say, cost and justice, they are related. If you're saying that this is an open court system, everybody, regardless of the social background, have access to justice. But then, when you come to the court, there's a big gate. We collect fees from you. You can't enter. How is that an open court? How do we uphold justice if the fees is the barrier? So, do you appreciate what I'm trying to say here? Cost can impact access to justice here. And that's the injustice here. The other problem is delay. It takes up to 3 to 5 years in these courts. Can you imagine in a road accident claim, if you're going to compensate the claimant after 3 years, after 5 years, in these 3 years, who's going to pay the bills? Who are going to pay the bills here? You did the negotiation case, right? Do you remember Anil Kumar? How can you forget Anil Kumar, right? For some of you, that was your first subject, right? That young man suffered very bad injuries. Imagine if he's going to wait for 3 years, his medical cost, his nursing care, support, who's going to bear all this cost? So do you realize why was he desperate to compromise and negotiate and not go to the court? So this is definitely a problem here. And these lawyers now, they usually are not bothered about the time. Lawyers are more concerned, even if it's taking me 3 years, in these 3 years, I will still be paid. Do you see? Okay. The next problem is the limited access to justice, which I will explain to you after our break. So now we'll stop for break. After the break, I'll just finish this little part here, the problems, and then I'll tell you the reforms introduced by Lord Wolf, okay? And we'll review his reform shortly. Do you understand? Are you following the flow so far? Okay? Do you have any questions? Okay, I'll see you at 8.
Nirmala, Zira here. Can I just double check? Why is it called like wool reform? What is it about?
Because it was, the reform was proposed by Lord Wolf. So that was his second name. So whenever reform is, like the Jackson Review is by Lord Jackson. Yeah.
Okay, got it.
After them.
All right, thank you.
Welcome.